think I'll stop there and leave the rest to the interactive portion.
Thank you. Professor Pepe?
Okay, so first, thank you for inviting me, and it's great to be here. I had the pleasure of going to the FTC's workshop in November, and it's great to follow up here and keep hearing about all this. So I'm just, because it's sort of the lunchtime, pre-lunchtime panel, I'm just going to throw a lot of hand grenades around and see what happens. Just about 4 different topics. The first is, I think that the title of the conference is a little bit wrong. I don't think the question really is, what is your car saying to your shoes? I think the question is, what is your car saying to your insurance company, your credit card company, your bank, your landlord, and your employer, right? Because I really don't care what my car is saying to my shoes, but I do care a lot about what my car is saying to those other kind of economic actors. So the first thing I want to talk about is the possibility that on the Internet of Things, everything reveals everything. And what I mean by that is sensor data are so nuanced, so rich, that it's quite plausible that what we're going to discover is that almost, I won't go quite as far as everything reveals everything, I'll say almost everything reveals almost everything, that lots of different sensors can tell you lots of different unexpected things. So for example, your car is chock full of sensors, and we know if you have Progressive Snapshot, anybody have Progressive Snapshot car insurance that gives you a discount if you drive better? Okay, so you don't, but millions of people in the United States do. You put a little device in your car, you drive for 6 months, it tracks how you drive, and they give you a discount of up to 30–40% based on how you drive. That makes lots of sense. You can understand that your car's performance or your driving performance would be relevant to your car insurer. FICO decided they would make a FICO driving score using that kind of sensor data. It's FICO's business to score things, makes sense. But what then they figured out was the FICO driving score correlates with your FICO credit score. Now, if you think about it, that's not exactly surprising, because if you're a responsible, safe, careful driver, you're probably a good credit risk. But what gets interesting is, if the principle of everything reveals everything turns out to be true, not only does your car data probably correlate with your credit score, it probably correlates with your employability. It probably correlates with your insurability on a lot of different ways. Your landlord would probably be interested in that data. And I would guess that your Fitbit data also correlates with your credit score. I would guess that we could figure out from how well and how hard and how diligently and how routinely you exercise, lots about your personality, how much Ed is asleep last night, lots about his personality that an employer, an insurer, a bank would like to know, and so on and so on and so on. So the first problem we've got is we're not used to a world where lots and lots of different data sources are revealing things that you can draw really, really good inferences from, that have lots of economic uses across industries and sectors. And we're going to have to really wrestle with this use question. So for example, 4 states, only 4 states, have passed laws dealing with event data recorder data coming off of cars that have said an insurer cannot demand access to your car sensor data as a condition of insurance. One state, Virginia, has said if you, that an insurer cannot draw inferences or adjust rates based on your refusal to give them access to your car sensor data. So there's some really interesting use questions about, do we want to constrain these uses into silos that make sense to consumers and consumer expectations? How are we going to handle that? And as a footnote, FICRA is not going to be very helpful. Sorry to the people. Well, anyway. So that's the first point. Everything may reveal everything, and that's going to be a problem. Number 2, on security. I'm not going to talk a lot about security, because the former panel really did a great job of talking about security, but I will say there are 40 some odd state data breach notification laws in this country at the moment. Only one of them, Texas, does the law apply at all, even arguably, to sensor data coming off an Internet of Things device. So if Fitbit got hacked and somebody stole your Fitbit data from Fitbit servers, they do not have to tell you. And the reason is those laws are all written in a very narrow way to say, most of the time, they have to steal your a data set that contains your name and usually something else, like your social security number. But the something else is never defined in any of those laws in a way that would include sensor data coming off of an Internet of Things device. The previous panel talked about should we reform data breach notification laws. I think we should, but the way we should is we should expand their scope to focus on sensor data. It's the sensor data that matters in a lot of ways, because if I can steal all of that, or if somebody steals all that, my guess is we're going to get to the point where consumers want to know that, right? They want to know that their Fitbit data, because you can draw some pretty amazing inferences about what someone's up to from Fitbit data, and I'll just leave that to your imagination. Consumers are going to want to know that that data is out in the wild and has been stolen. And the reason, number 3, is re-identification, and I won't spend a lot of time on this, but my colleague Paul Ohm sort of blew open this topic for lawyers at least by writing about the possibility of re-identifying data sets. More recently, Schwartz and Solev have written a really big and interesting paper saying, look, maybe the idea of personally identifiable information needs to change a little bit. We need to have kind of a spectrum along the lines that Joe was sort of heading down of what counts as personally identifiable. All I'll say for now is sensor data, Internet of Things data, are particularly easy to re-identify. So if we were worried about other data sets, Internet of Things sensor data sets are way more worrisome. And the reason is sensor data sets are incredibly sparse. It turns out, for example, well, I'll just give you a great quote. The former chief technology officer or information officer of the CIA was quoted saying that they can 100% identify you as an individual from your Fitbit data. And the reason is everyone's gait is different. You walk differently from every other human being on the earth. And therefore, if I videotape you walking and I analyze your gait and I look at the Fitbit data, I can figure out which data is yours, even if it's been a de-identified data set. Similarly, it turns out lots of other sensor sort of Internet of Things data sets are easy to re-identify. MIT came out with a fantastic study last year. If you haven't seen it, you should go read it, about smartphone location data. And they showed how incredibly easy it is. They took a data set of 1.5 million smartphone users, all their locations streamed 24 hours, 7 days a week over a 1-year period. And the question they asked was, how many times would I have to know where Joe was in order to pick him out from that 1.5 million anonymous users in the data set? And the answer is 4. If I know where Joe was 4 times in a year, so in a 1-hour period, I know he was here today and he was at his office yesterday and he'll be at his office tomorrow, I can figure out which of that 1.5 million users Joe is just from those 4 data points of the entire year. Now, if you don't understand what I just said, go read the paper, but that's a staggeringly small amount of information I need to pick Joe out of that data set. And we're going to have a real problem, I think, with how we deal with personally identifiable information in this context because of the threat of easy re-identification of sensor data. And then the last thing I'll say is about privacy policy. So I've just finished a fairly big paper on the Internet of Things and how to regulate it. You can download it from SSRN if you want. That's my just unabashed pitch. But one of the things I did is I went and bought 20 different Internet of Things objects. And I thought, I wonder what the consumer experience of buying one of these objects is and how much notice they get about privacy and et cetera. And the answer is it's just horrendous at the moment. So for the corporate counsel in the room, I really would encourage you to focus your clients on this. And I'll tell you how it's horrendous in 3 ways. One, you can't find the privacy policy for many of these objects. So I talk in the paper about this little object. I don't want to pick on them unnecessarily because all 20 were bad. But this is a little breathalyzer, right? So you buy this little thing and you can plug it into your iPhone and you breathe into it and it records your blood alcohol content. When you open the box, there is no mention anywhere in this box that there is any privacy policy that relates to the use of this device. So you open it and out comes the little thing, which is cute and sleek and black, and a little 17-page manual. Nothing in the 17-page manual refers to anything having to do with privacy or data or information or a website that you can get it from or anything. So then I thought, well, okay, I'll just download the app because the app will have a privacy notice. No privacy notice in the app. The website does have a privacy notice, but you don't have to go to the website in order to start using the device once you've downloaded the app. And it turns out that even the privacy policy, once you find it, is pretty pretty incomplete. So one question is, where do we want notice to happen for these objects? It's sort of your smart bottle, but even not talking about a smart bottle, is it in the box? Is it in the user manual? Is it on the website? Where is this supposed to happen? That's one problem. And the second problem is, once it happens, most of these 20 policies that I reviewed were written by really good privacy lawyers in the mindset of writing an internet website privacy policy, not an object sensor, sort of sensor device privacy policy. So they tell you things that are useful for website browsing, but they don't tell you much about what sensor is in here, what data is it collecting exactly, where is the data stored, on your phone, in the cloud, how long is it stored, all the kinds of questions that a consumer might actually care about. And Heather Patterson, who's on a later panel, has done some of the best work, I think, on what consumers expect in this context. But none of that right now is in any of these policies. The best one I saw was Nest thermostats, which was just acquired by Google. They have a pretty good privacy policy. The rest of them are pretty horrendous. So that's going to become an issue too, both for the FTC and for states like California that have really focused on privacy policies. What do we want in there? And you know, I'm not a huge fan of policies in general, but if we're going to have them, because they're one of the few ways we can regulate this sort of thing at the moment, they might as well be useful. So I'll stop there.
Professor Geisfeld?
Thank you. So I will talk about the tort implications of some of these developments. Mostly when you read in the paper about the intersection of tort law with these new technologies, the concern is that the tort system is going to end up driving the driverless car off the road because the liability costs will be so onerous that these products will never be commercially viable. It's a clearly interesting question. There's going to be a lot of litigation over that, but I think the end game of that is fairly predictable, that in fact these products will be subject to limited tort liability, and they won't be driven off the road, at least by the tort system. But what I want to talk about instead is an aspect about the information that we've been discussing here that poses a potential benefit for the individual who is the subject of all of these data searches. And so obviously there's a concern about privacy and so on. But there's a flip side to all of this. As other parties gain more and more information about what we're doing, the risk of harm that was alluded to earlier is something that could actually be controlled or mitigated by third parties. So you're in a situation in which you're vulnerable, but you don't know about it, but some other third party that has collected a great deal of information about your activities is either aware of your plight or ought to be aware of your plight. And so the interesting tort question is whether or not that third party has a duty to let you know about the danger that you face and whether they should have to take any other steps, perhaps, to protect you. And so there's a way in which, in other words, all of this information that gets disseminated out there in the world could actually work to our benefit outside of ease of product use and so on. It could actually protect us from threats of which we are unaware. Now, the question of duty in tort law is just that idea that there has to be an antecedent legal obligation that runs between the two of us before you could be responsible for anything bad that happens to me. And the baseline proposition is always that there's no duty to rescue. If you've taken torts, you know this. You stand on the street, you can watch somebody walk into an oncoming car, and although it'd be easy for you to alert that person, you have no obligation to save them. The rule instead is that you have to typically engage in some kind of affirmative act that subjects another party to a foreseeable risk of harm. And the harms that I'm interested in here are physical harms, bodily injury, damage to tangible or real property. Now, in those circumstances, then, given the creation of that risk, you have a duty to control it in a reasonable manner. That's just the negligence rule. Now, to see how this plays itself out in the world of IoT, the products are the most obvious example to use, and in particular the automobiles that are being sold today. So you sell a product, of course you create a product risk to which the consumer is exposed. The duty for products is premised on the idea that the consumer isn't aware about the risk, and therefore it's the obligation of the seller either to warn about the risk or to perhaps design that risk out of the product with reasonable modifications of the design and so on. But notice, of course, the idea that the individual doesn't know about the risk. The seller has information about that risk and therefore is obligated to disclose it to the consumer. That's the dynamic that I think is interesting more generally here. Now, traditionally within tort law, there was the duty to warn terminated with the sale of the product. And the idea was that it's extremely difficult to get into touch with consumers after you sold the product. Maybe they sent in warranty cards or something like that. It's also difficult to monitor product use after you sold it, so you're not really aware of any risks that are created post-sale. And so traditionally there was no post-sale duty to warn. In the 1990s, the Restatement Third of torts ends up adopting a post-sale duty to warn, and you can see how the emerging widespread use of databases and so on makes it easier to keep track of your customer base, makes it easier to get in contact with them, and so on. But even the Restatement Third said, look, it's very difficult to monitor product use post-sale, so how are you in general going to know about any risks? And moreover, it still is oftentimes very difficult to warn, so we recognize a post-sale duty, but we think it's going to actually be applicable in a limited number of contexts. Most states have adopted this, and the trend, I think, is clear that it will end up being almost uniformly adopted, if not uniformly adopted. But notice how these factors are all completely transformed by IoT. So first of all, of course, monitoring product use post-sale becomes incredibly easy, so that you become aware of product risks that you may not have been aware of at the point of sale, but now that you're seeing how this product is being used out in the world, you, the seller, become aware of risks. So now you have knowledge that is in your possession that you have gained due to your ability to monitor post-sale product use. So then the tort question turns on your ability to communicate with the users of the products. And again, of course, the same thing that allowed you to monitor their product use is more or less going to enable you to get in contact with them to let them know about any hazards that they're exposed to at this point in time, of which they are unaware. So the dynamics here, just in terms of the basic factors of the post-sale duty to warn in the product context, is clearly going to point towards an expansion of the duty. It's going to simply be easier to communicate with consumers about risks that we learn about by new developments and so on. And so the duty is going to be much, much more generally applicable than what the Restatement Third contemplated in the mid-1990s. And you can think, if you just think for a little bit about cars that are sold today, you can see how this all plays itself out fairly straightforwardly. The more interesting question, I think, is to what extent does this logic move outside of the product's context? I think all of the product issues are fairly straightforward. We just have change in the facts that create a more widespread duty to disclose. But what happens when we move out of the product seller consumer situation to situations in which we've got a third party who's collected a lot of information about us, and they know we are in a vulnerable situation, but they didn't actually create the risk in question. So now I want to push it closer to what we call the duty to rescue. They know we're in danger, but they haven't actually created the risk in question. Do they have a duty to disclose the threat to us if they could get into contact with us in a way that would help to protect us from harm? Now, in order for tort law to recognize a duty in this context, short of recognizing a duty to rescue, which is not going to happen, nor do I think should it happen, the doctrine here is one of special relationships. There are going to be situations in which one party doesn't create the risk, but nevertheless is in a situation to prevent the harm from occurring. So landlord-tenant, the landlord doesn't create the risk of burglary, but is clearly in the best position to prevent burglars from entering the building. And so the landlord has a duty to protect the tenant from third-party criminal attacks. Now, the interesting question that these developments are going to pose as in the context of special relationships is the actual bases for special relationships, I don't think is very well articulated or well developed within tort law. It's kind of one of those, we know it when we see it, but when you look at the cases, there are certainly instances in which courts are stretching to find a special relationship, more or less on the ground that we can somehow make this an exception to a general duty to rescue, and it just so happens that the defendant here was particularly well placed to protect a vulnerable plaintiff. If you think about it in those terms, you could start to see that there could be a basis for formulating a special relationship simply on the ground that if somebody is out there collecting information about me for their own benefit. I haven't consented to it, they're just doing it, or perhaps they gave me information in a privacy notice that I never read. But there's an argument you can make that there's a quid pro quo that's entailed by your benefiting from information about what I'm doing out there in the world. And that quid pro quo is insofar as you have learned something that places me at risk, and you can communicate it to me easily. It's not just simply knowledge, it's also an ease of communication. But in light of those situations, is that special relationship created just by the fact that you have been, interested in what I'm doing out there in the world? That, I think, is going to be a real pressure point. I have no idea how it's going to develop, but I think that's something that's going to, push tort doctrine in a way that could result in rules that are going to be more onerous for those who are collecting the information, but providing a benefit for those of us who are being studied in this particular fashion. Thanks.
Gerard.
Great. I'm Jerry Waldron, and I am a partner at Covington and Burling. I did spend many years in government. It was not at the FCC. I was actually the senior counsel on the House Commerce Committee for many years. So I actually, I think about this, the first privacy bill I ever worked on, and some people may remember the situation with Robert Bork when his videotapes. I actually helped draft that bill, and then we extended that to the cable industry in 1992, and I helped draft the Telephone Consumer Protection Act and also the CP&I rules. And I will tell you, privacy issues were a lot easier then. We have moved with this Internet of Things into a very dynamic area, and I really was stunned and really amazed at the discussion about shoes and pencils, because that made some of the things that I think about this, because I focus on the transportation sector, as much harder. So I'm really glad the conversation on this panel turned to cars, because I think it's a lot easier. And the issue that I would sort of suggest is that I think consumers and companies, my clients, and regulators actually should look at the nature of the device differently, because when you think about some of these hard issues and the FTC's fair information practice principles, and you think about applying those to a pencil, really? How are you going to get that notice? How are you going to get that transparency? If you think about it, applying it to an automobile, I actually think, and I love sort of the example of the I actually think that those principles actually work fairly well. And so I would suggest that people need to take a more nuanced view. I will tell you, there is some school of thought as, well, it's hard for everything, so we shouldn't do them on anything. And I would suggest that I think consumers are going to have different expectations about their car, which is either their first or most expensive asset that people own. I think companies are going to have a different sort of notion, and I would suggest that regulators should have a different notion about the difference between the pencil or your shoe and your car. So let's think about what are the kinds of things that your car generates. Some things are obvious: precise location, vehicle speed, rate of acceleration, to the Progressive Insurance app, cornering force, headlight status, seatbelt status, tire, ambient temperature, number of people in the vehicle, whether you have the radio on, what are the conditions outside, driver attentiveness, cell phone use of the radio, navigation system, apps, all interactive, all tied with how fast were you going, whether you were changing lanes, whether your turn signal was on. All of this information can come from your car. The earlier panel talked a lot about security, and I was also at the excellent FTC panel on the Internet of Things on the transportation panel, and it opened with this scary scenario about hackers coming in and taking over your car and driving off the road. And the security people, and I believe in security, and I'm glad that a lot of people are worried about that and focusing on that, but focusing on the privacy issues. So let's take the sort of core notion of the FTC's privacy practice principles and apply them in the context of a car. So obviously the big one is transportation. And I'm sorry, the big one is transparency, I should say. Now, it's more complicated than when you go on a website and you click it and you say, yes, here's the notice, and you have to scroll down, and make sure you scroll down before you hit the yes button. That's pretty obvious. When I pick up my pencil or when I pick up my bottle of water, that's sort of less obvious. When I buy a car, that's actually one place where you could give the notice. But given with the FTC's, given with the FTC's principle that you want to sort of give the notice when it is most important and most timely for the consumer, I would suggest that you actually can give it in the dashboard. So when you're logging on when you're turning your car, I should say, when you're logging on your car, that's a feature. When you're turning on your car and you're turning on the dashboard, that the notice can be there. Yes, it could be in the point of sale or the lease, but I don't think that's sort of timely. And then in terms of consent, sort of who owns and controls the data is going to be relevant to whether it's your refrigerator or your washing machine, but I think it's especially, and maybe your electric utility would like to get access to some of that information, but I think it's especially relevant in the context of the car, because where you travel and where you go is perhaps even more sensitive than to some people than how long you slept last night. And so in terms of sort of getting the consent, I mean, our notion is the notion that it should be affirmative, express consent. I think this makes sense in a vehicle setting, and I leave to others to debate whether it might not make sense in other settings. I think the sort of the terms of it also is controlling. Who do you share it to? Do you share it with your insurance company? Progressive, you sign up for it, that's a bargain. You can lower the price that you pay. That's a trade-off that consumers can make. Do you want to share it with the Ford Motor Company if Ford can track you and maybe say, gee, your battery's running low, you need to come in for a checkup? Maybe you want to share it with your local auto shop that will let you know, and you don't want to share it with Ford. So the notion of who can control this data, it's something that we encounter all the time in the online setting, but in the product setting, people are paying $20,000, $30,000, $40,000, $50,000. They are buying that asset, and when they take home a lawnmower, it's their lawnmower, and the fact that somebody could get information generated by their lawnmower, that's a ridiculous notion to us. And sort of query whether in the vehicle setting, you pay tens of thousands of dollars for a car, you are generating this information, who owns and controls that information? Do you co-own it with the auto manufacturer because presumably they need it for operational details? Do you say they can get it but they can't use it for marketing purposes, which is what we frankly wrote into the CP&I law 22 years ago? So these are the sorts of issues in the transportation sector that I think it's worthwhile to look at, and frankly the amount of spectrum and data that is being dedicated to this space is remarkable. The Federal Communications Commission has a proceeding on this one, and the smart vehicle, smart transportation sector. So your car is going to talk to the road, your car is going to talk to the intersection, your car is going to talk to the car in front of you and the car behind you, in addition to you. And it's going to be generating all of this data in this large context. Just to sort of sum up, I think this is a fascinating topic, and I like the notion that we're looking at it in a variety of ways, from pencils and shoes to cars. And so the walkaway message, I would say, is I think a nuanced approach in looking at each of these areas individually sort of reflects the reality of consumers in this space, and I think companies should be wise to pay attention to that as well.
Thank you. Tom?
I'm Tom Halkett, and among other things, I'm an adjunct at the law school.
Can you grab a microphone?
Can you hear me now? I'm an adjunct at the law school, and I teach a course in entrepreneurship law, which is the law relating to founding and getting financing for a startup company. And Joel asked me to address the issues that Internet of Things startups might confront in the corporate and financing areas. To some extent, it's a little different than the other topics in this conference for two reasons. One, the law is general; it's not specific to Internet of Things companies on the one hand, and on the other hand, with a couple of exceptions, a lot of it is fairly well established. It's also a fairly large topic. We devote something like 20 class hours to what I'm supposed to do in 8 minutes. So, to get started, I'm just going to deal with some securities law issues. And by securities, I mean stock, not more than one thing to keep your privacy when you use these devices. Securities are important because that's how startups raise money. And securities are regulated, very heavily regulated, by both federal and state governments. On the federal level, there are a number of securities acts, but there are two that are fairly important in the context that we're dealing with. One is the Securities Act of 1933, otherwise known as the 33 Act, and it regulates the issuance of securities by... Okay. Regulates the issuance of securities by anyone, and that's companies, basically, who are issuing securities for the first time. So that's any company, large or small, but it applies certainly to small companies as well as large. The second one is the Securities Exchange Act of 34, known as the 34 Act. Securities lawyers are not terribly creative in terms of the abbreviations they give the acts, but the 34 Act regulates the transfer of securities from one person to another. The Securities Exchange Commission is the regulatory body that's been set up to administer these acts. On top of all this, there are virtually every state, and I think every state, has its own separate securities regulation scheme. And these regulation schemes usually don't apply to public companies, but they do apply to private companies issuing private stock. And they don't apply in the public scheme because they're preempted largely by the federal acts, but for private issuances, they can be preempted, but they're not always. And all of these state acts a lot of them are different. There is a uniform state act, but it has not been enacted by many states. New York's act is particularly crazy, and I'm not going to get into it, but it's one that gives everybody fits. And the state acts are called blue sky laws because from a quote in a Supreme Court opinion in 1917, which likened the sale of securities to the sale of so many feet of blue sky. The main act that I'm going to talk about is the 33 Act. How does that work? Well, first of all, it doesn't regulate securities. It does not apply to securities in terms of requiring the registration of a security. Most of you may be familiar with the term registration, the registration statement. You don't register the security, though, you register the transaction. So each time a security is sold or given, you have to find an exemption for that transaction. The security itself doesn't carry with it its registration from a previous registration statement. Now, you either have to register the security, and that requires the registration statement, or find an exemption. For private companies, the chief exemption is Exemption 4.2, which is sales not pursuant to a public offering. If it's pursuant to a public offering, you have to do a registration statement. You probably all have seen parts of registration statements, the common prospectus. If you're doing a private offering and you can come under Section 4.2, you don't have to do that. But there was always some doubt as to what it took to be private. So in 1982, the Securities and Exchange Commission issued a regulation called Reg D. Reg D provides safe harbors, i.e. if you comply with Reg D, you will be deemed to be a private offering, and you will not have to do a registration statement. If you don't comply with Reg D, you may otherwise still have a private offering, but you're not guaranteed it. And Reg D has largely remained unchanged since 1982, with the exception of addition of a couple of other sections later on, and some fiddling with it with in the Dodd-Frank bill, until the Jobs Act in 2012. And I'm going to get into that in a little bit more detail, because I think the Jobs Act has two aspects that are particularly important for Internet of Things startup companies. And Reg D basically, there's a list of things that you have to do to comply with a Reg D offering. There's restrictions as to amount, there's restrictions as to who you can sell to, and in the original form of Reg D before the Jobs Act, there was a restriction that you could not do your offering by way of a public announcement or a public offering. It could not be by way of a public advertisement. You couldn't have a tombstone ad in the Wall Street Journal, for example. So that's the basic way the Securities Acts work. I mean, I've just done a Securities Act law school course that takes a whole semester in about 3 minutes, but I will move on now to the main point of what I'm going to speak about, which is the myths that startup companies come with about the securities laws. And there are 4 that I'm going to deal with in specifics. The first one is, I don't have to deal with the securities laws. It doesn't apply to startups because I'm selling the stock to my Aunt Matilda. We're a small company. We're a company that, we do good things. You'll hear a lot of excuses why the securities laws do not apply. Well, that's myth number 1. There are 3 ways you can do an offering in the United States. You can comply with the securities laws and do a registration statement, which is expensive and time-consuming. You can find an exemption from the securities laws, and the principal one is Reg D under Section 4.2, or it's illegal. And that's it. There are no other exceptions. So that's the first myth. The second myth is the myth that relates to finders. I don't know how many times someone will come to me and say, gee, I met this guy who can help me sell the stock in my private offering. He knows some rich people. And what's good is he doesn't want any cash up front. He'll just take a piece of whatever he sells. So it's a no-risk deal. And then the question becomes, is the gentleman a broker-dealer, a registered broker-dealer? And most of the time, the answer is no. And this is a very, very common occurrence. Notwithstanding the fact that it's a common occurrence, and notwithstanding the fact that, among other people, the ABA has commented on the fact that it's a common occurrence and it should be legal because it really doesn't hurt anybody, the SEC has consistently taken the position that if you sell stock through a finder who takes a commission as a percentage of the deal, and he is not a registered broker-dealer, that's illegal, and it can affect the legality of your offering. So that's myth number 2. Myth number 3 is that the Jobs Act. Now, the Jobs Act was passed. I assume everybody's familiar with the Jobs Act generally. It was passed a couple of years ago. It was one of those great acts that Congress and the White House and both sides of the aisle just got together and said, oh, we got to pass this to improve the climate for startups in the country. And in a rare show of bipartisan fervor, they passed this act. Well, the Democrats liked it, the Republicans liked it, the White House liked it, the Congress liked it, and the SEC hated it. So what happened? The SEC was charged with implementing the Jobs Act and creating rules and regulations under it, like they do for all the security statutes. And because they hated it, they really eviscerated it in a number of different ways. So let me deal with 2 of the provisions of the Jobs Act in 2 different myths. The first one is, by the way, the SEC also was painfully late in issuing its regulations. Even though it was mandated by Congress, it seemed to just largely ignore the mandates, and it was not days late, but months late in terms of issuing mandated regulations that had deadlines that Congress had imposed on the SEC as a matter of law. So the first myth, or the third myth I'm going to deal with, is that crowdfunding is going to be the panacea of raising money for startups. Now, I don't know if all of you know what crowdfunding is, but crowdfunding basically is, instead of raising a fair amount of money from a small number of accredited investors. An accredited investor is a defined term under the Securities Act. It's basically someone who's rich, or at least it used to be someone who's rich. Inflation has eaten away the definition of richness, and it's now someone who is comfortably middle class, I suppose. But the crowdfunding is, instead of raising money from that kind of people, you raise a small amount of money from a large number of people on the basis that most people can afford to lose a few $100s. That kind of motive is what's behind crowdfunding. That's a questionable motive in my mind, but it follows from, and I'm sure you're aware of Kickstarter, which existed before the Jobs Act. Now, Kickstarter is a website that raises money for people And everybody says, well, if Kickstarter can do it, then it must be legal to sell stock in a crowdfunding scenario. Well, until the Jobs Act, that was wrong. And Kickstarter wasn't selling stock. What Kickstarter was doing was giving something away. You didn't get a percentage of the company. What you got was maybe a coupon to buy a product, or the good feeling in your stomach of having done a societal good by giving some money to a worthwhile startup. But Kickstarter did not sell stock, notwithstanding the fact that everybody thought it did. Now, the crowdfunding provisions of the Jobs Act did make crowdfunding legal. And, but then they said to the SEC, go pass some regulations to make this quick and easy method of raising money to implement it. And the SEC has issued some rules for proposed regs, and I'm just going to go quickly through some of them, and to give you an idea of what the SEC did and how they eviscerated it. First of all, they put a cap. Second of all, they put a maximum investor amount of $100,000. Thirdly, they made it. They required that the funding be through registered intermediaries. So you have to do everything through a registered broker-dealer, essentially. In addition, unlike a private placement where depending on who you're selling to, there is not a filing requirement of any significance, there is a significant filing requirement with respect to people who do crowdfunding financing. The issuer must file on EDGAR, which is the SEC's computer website, its name, it's the names of the directors and officers, their experience in the previous 3 years, the names of any beneficial owner, descriptions of the business, the number of employees, risk factors, and on it goes. There's about 20 different things that you have to provide information for. There are also ongoing reporting requirements, so which private companies do not have, but if you crowdfund, you do have. So the SEC has not made it easy to do crowdfunding. That's myth number 3, that crowdfunding is going to be a panacea. It is not. And finally, myth number 4 is that in the Jobs Act, the Congress said that mandated that the SEC should implement rule amendments to Reg D to allow accredited investors, and remember those are rich people, to buy private stock in what are essentially public offering, public announcements. Previously under Reg D, even rich people couldn't, for the offering to qualify as a Reg D offering, it had to be not through a public means. You couldn't make a general announcement of it. And what a general announcement of an offering was open to some doubt. Could you get up at a conference, for example, and say, I'm selling stock, anybody want to buy it? I'm not selling stock, by the way. So there was some doubt, but at the very least, people were fairly, you couldn't advertise in a magazine or on the web or things like that. Congress said to the SEC, okay, accredited investors don't need protection, so if you're selling to only accredited investors, that can be done through a public announcement, public offering. So the SEC said, okay, we think that's a really bad idea, but you told us to do that, so we did it, so we'll do it. And what they did was they enacted the following regulation. Previously, in order to verify that someone was an accredited investor, you just had to he needed to sign a statement that he was an accredited investor because of whatever, he fits the following test. Now, and that still holds true if you don't do your offering by way of a public announcement. Now, if you do your offering by way of a public announcement, you need to, the company, the issuer, needs to verify the fact that the person is an accredited investor, and the SEC suggests that you get copies of his tax returns, his bank accounts, and so forth. I question how likely private investors are rich private investors are going to want to give up all that information just so that they can buy some stock. I think the SEC has effectively neutered the provision. So that's myth number 4. And with that, I will end the presentation because I think I don't know if I've gone over time, but I've certainly come close.
So we're going to take some questions, open it up for discussion. But first, let's give a hand to our panelists for their remarks. All right, so, as I was listening to the various presentations, the questions just came tumbling out of my mind. But undoubtedly, your questions are more interesting than mine. So why don't we, if it's okay with Joel, open it up to questions from the audience to spark some discussion among our participants. Sir in the back. And if you could keep your voice up, I think we may have a traveling mic. If not, I'll repeat the question.
We do have a traveling mic. This is a question for Professor Geisfeld, and I'm sorry if I mispronounced your name. On the tort area, one of the things you talked about, and I think it's the kind of thing that has a lot of unpredictability to it, but one of the things you talked about is the ease of communication both ways. It seems to me that if you're talking about the ease of communication back from the company or the data gatherer to the individual, what you're also doing is you're providing a strong incentive for them to actually have a business reason to maintain personally identifiable information of exactly the kind that those people who are concerned about privacy say the company shouldn't maintain and should handle. Well, how do you think you address that balance?
Well, actually, that's one of the hard questions that a court would have to resolve in order to determine whether such a duty should be recognized. It's one thing to say with automobiles right now that we already have that, but the kind of issue that you're alluding to and that I had discussed earlier, when you decide to recognize a duty within tort law, you worry about the collateral consequences that a duty would create. It's not just about saving the plaintiff in a particular set of circumstances. You worry about how this obligation is going to play itself across a category of cases, and that if across the category of cases you start to have bad outcomes, that's a cost of the duty that you have to account for, and the cost could end up swamping whatever safety benefit we might get out of this. And it's pretty clear to me that the primary cost that we would worry about here is the cost of privacy, exactly of the sort. Aren't we incentivizing the kind of behavior that you're talking about? Isn't it predictable that as a result we're going to have further encroachments on our privacy? And isn't that a reason to say no tort duty? And the answer is absolute. That is a persuasive reason. How you do the balancing, it's an empirical judgment that that courts will have to make. But there's no question that factor is central to whether or not a duty of this sort ends up making sense or not.
Any other panelists want to comment on that?
I want to perhaps scope the question rather than comment on it. And the scoping goes back to the ecosystem concept. Because if you think about the vast majority of sensors that are going to be deployed, they are not, in fact, necessarily communicating back. The vast majority of sensors, a sensor that's going to be on a tag that's going to be on this bottle, things of that nature will not have, they're a narrow passive tag. They have a limited set of communication capabilities. We're going to have RFID dust, which already exists today, which is RFID that's about the size of a period on a piece of paper. So if you strike a period with a typewriter or a word processor or a computer on a piece of paper, that's the size of the tag with an embedded antenna. And it can only actually communicate to the little dot that's next to it. And the concept is you would put these kind of things in paint and you would create a mesh array. And then the mesh array would all speak to themselves to say stuff like, I think I'm getting warm. We should alert the house system I'm getting warm. And then the house system makes a decision of some kind related to the blinds or the cooling system or things of that nature. What does have this communication capability is all of the sexy things that we like to talk about, which is the Fitbit, which is your car, which is things of that nature. But those also tend to have control interfaces that are available to you, whether through a mobile phone or some kind of a programming function. So that may be the place where you help identify some of those tort functions also, because there is a control parameter. On these little things where the most you could ever hope for is the washing machine label, you will never be able to have that exchange, and the foreseeable risk related to that will likely only be limited to what the company can figure out it's going to be used for ahead of time, and maybe what it disclaims on the label, as they do already today. And in the United States, you can disclaim less and less over time, because, I mean, you have to warn people about some things that seem to be fairly obvious these days.
Question? Next question? In the back?
So it sounded like a lot of you talked about how traditional online privacy methods don't really apply to the Internet of Things, like privacy policies or the FIPS aren't really applicable. So I was wondering how you see the future of regulation for privacy protections, like through a revised notion of tort duties or contract law, or more of a regulatory legislative framework.
Anybody?
I do think the FIPS apply. I just don't think we've applied them yet. So there are two questions, right? I mean, one is, do they apply at all? You mentioned transparency. I think you can certainly come up with ways to get meaningful or quasi-meaningful, at least, consent in the Internet of Things context. But we're just starting to figure out these consumer devices, and the example I gave is a good one. There are lots of others I can tell you about where consent, the notice is pretty weak, and the consent is even weaker if it exists at all. But I do think that in addition to notice and choice, we're going to face the question that nobody in privacy likes to talk about very much, which is use constraints. When are we going to say, and I'll get accused of paternalism immediately, but that's okay. When are we going to say, sorry, it doesn't matter what notice you give, you cannot use that data in that way? And that's the example I gave of, certain states limiting what an insurer can demand in terms of data out of your event data recorder from your car. Obviously, regulations like FICRA and some others, some of the substantive siloed regulations at the federal level do that as well. I think that's going to be where the fight is going to happen, and I think it's going to happen at the state level, not the federal level. I think states are much more likely to move than Congress, and to start saying things like, no, I'm sorry, actually, you cannot, if you're a lender, use Fitbit data, or you cannot, if you're a lender, use driving data, or you cannot, if you're a lender, use your Nest thermostat data to make a credit decision, because we don't think that consumers expect the data to migrate across those use boundaries. You've already seen states do similar things when they've said things like an employer can't use a FICO score in making a hiring decision. I would guess states like California and other states are going to start zooming in on these sensor data because of the incredibly powerful inferences you can draw from them. So I think the fight is largely going to be substantive, not procedural, and it's going to be state, not federal, and it's going to be context by context. It's going to be essentially a legislative ground war. You're going to go through one context after another, and the reason is going to be something bad is going to happen. So somebody's going to use Fitbit or driving or some other data in a way that freaks out consumers, and a state is going to say, whoa, we didn't even know you could do that, and they're going to jump on that, and you're going to start to see ripple effects as that legislation spreads.
And I would add to that, and that's sort of the point I was making. I think FIPS is a great place to start. And it may not work for every product, for every setting, but it's a well-developed framework, and it's a useful jumping off point in the conversation. I will say I agree completely about federal legislation. I started by rattling off 4 bills that were passed in 8 years, and there haven't been 4 bills passed in the next 20 or 18 years. So I think it is going to be a state effort, not a federal effort, if there is going to be legislation.
I think FIPS are perfectly applicable. They are occasionally challenged in the way they are applied, but the statement that was made was FIPS is a framework, and too often people think FIPS is notice, and if I can't give you an appropriate notice in the old-fashioned way we used to give notice, then I don't have a FIPS obligation. Well, the answer is if you're a little challenged in notice, then you're going to have to beef up the other part of the FIPS, because it's kind of an interlocking set of concepts that you're dealing with. The other thing is, I actually think it's less the Internet of Things that challenges FIPS as much as some of the big data concepts in which you're looking at correlation analysis, which makes a notice and consent model more problematic. But that doesn't mean you just say, well, if I can't really do notice and consent in the way I used to, I forget about the concept. That's where you maybe start considering use-based models and other controls that you can put in place so that you can take care of the fact that you're giving a similar level of assurance, but perhaps you're doing it in a different way. So I think the FIPS remain as relevant as they ever have been. In fact, in some cases, they're more important now than they were before. And in terms of the way we're looking at these issues, this is not new. I'll take you back at least 10 years ago when Massachusetts was looking at a piece of digital signature legislation. And what they did was they had then, before they decided to pass the legislation, because they had to figure out what the impact of the legislation was on previous legislation. And we're going to have to think about this paradigm within the Internet of Things and privacy worlds. And what they did was they looked at every piece of legislation in Massachusetts that had the word signature, handwriting, or written signature. Because they wanted to make sure that by saying that you could have a digital signature, you weren't impacting a law that you didn't want that. And one of the things they decided was in situations of testamentary instruments, they didn't want to have a digital signature because a person who was perhaps 90 years old would not understand what the import was of pushing a button. But that person certainly understood the import of signing every page of a will that was going to dispose of their assets. And so they made policy decisions which was context informed as to which ones they would apply the digital signature law to and which ones they wouldn't. Because there were certain things, real estate was another one where they decided they didn't want to have a digital signature because they didn't know if the technology would stand the test of time in terms of a 30-year mortgage or things of that nature, and they decided they'd rather hold off on that at that time. But so these are the kinds of issues we're going to deal with, and the word context is tremendously important for everything. And unfortunately, when you do a law which is by definition kind of a top-down mechanism, context is really hard.
Following up on that question, if Professor Peppett, your scenario holds true and there are use restrictions passed by different state legislators, what does that imply for us, given the fact that these sensor collection devices will many times cross state lines? And so use and collection laws may vary. How do you think, and how does the panel think that will play out? As well as the choice of law issues.
The corporate lawyers in the room and the privacy lawyers in the room know far better than I do the headache that's going to create or already creates for their clients. Somebody on one of the earlier panels said, please, God, pass a federal data breach notification law so that preempts state law, so I only have to do it with one statute. I think we're just at the beginning of how messy this could get if we start seeing more substantive regulation at the state level also. That said, it actually doesn't take that many states. I mean, if you get California, you're going to get a whole bunch of privacy counsel in this room and elsewhere to pay attention right quick. So my guess is the first things that are going to happen is the FTC and the California Attorney General's office are going to start putting out soft sort of guidance on best practices and some of the security and privacy policy kind of contexts for and they should, but Commissioner Brill already has advocated for that. And that's going to help, right? Corporate counsel are going to respond to that a little bit. And then you're going to see us state, probably California, do something with a little more teeth. And then everybody's going to respond to that too. But you don't need everybody, right? You don't need every state to do this. You just need a few. Again, if a big state did a data breach, amended their data breach notification statute to apply to biometric and sensor data, everybody would pay attention overnight, and it wouldn't matter where you were selling your device. You would comply with the most restrictive state of importance out there. So, again, that's my guess of what will actually happen legislatively and on the regulatory side. I'll leave it to the corporate folks to tell me how horrible that'll be or not horrible.
I'm actually going to disagree a little bit with that at a couple levels. One, I'm in a law school. I see some law students here. Complications are actually good for lawyers. So let's be clear. We can deal with these complicated pictures. And privacy lawyers have dealt with complicated pictures. I think my colleagues in private practice on the first panel actually said, if there is going to be a federal data breach law, it should preempt the states. I agree with that completely. Do we need a federal data breach law? Be nice if it preempted it, but I tell you, and we have a large practice, a lot of clients. We get data breach panic calls from general counsel's office more frequently than we should. And the lawyers in our group, we have a chart. We know what all 45 states are. We go through. It's done, and you get the call on a Friday at 6:30, which happened 2 weeks ago, and by Monday morning it's all done. So people adapt to it and the complexity. And frankly, we have a lot of clients who we say, well, this is what you can do in most of the country, but then there's California. And that's a frequent sentence in our conversations. And some companies, big companies, sophisticated companies, some adapt and have a California approach and have a 49 other state approach. Some say, gee, I can live with it and I'm giving a little more protection than I should. So people take a different view with biometrics and those sorts of things. I agree completely with the point that people would sit up and notice sort of right away. And it would certainly lead to sort of copycat issues. I think it depends very much on the nature of the information, whether California drives a 50-state policy or whether companies react and isolate California from their compliance approach.
Yeah, so I'll take yes, I don't disagree people would react. I'll take the opposite view of the benefit. From a corporate perspective, complexity is not welcome. Because while at a law firm you may get a phone call and that phone call deals with one issue and the one issue you can resolve over 46 states because we all have the same chart, that's fine. But as a compliance officer, you're dealing with 150 issues simultaneously, and if all of them have that complexity, you're underwater immediately. And the answer is you've just increased the cost of your product because you've increased the cost of complexity that generates no benefit in terms of compliance. Because it is unclear that having Nevada have a different requirement related to encryption than Massachusetts, which then has a different definition of PII, is in any way a meaningful set of changes, except for the fact that some state legislator thought this was the best way to do it. Take a look at privacy legislation within the European Union. You have different privacy laws because a directive can be implemented individually in a country. So the Italian Data Protection Commissioner, and I knew the gentleman who was the commissioner at the time this law was passed, decided that an 8-digit alphanumeric passcode was what was required for privacy. There is no way a law should ever specify an 8-digit alphanumeric passcode, especially when the guy who's specifying it doesn't know how to use a computer. And these are things that happen. So I would argue, yes, we can all figure out how to manage complexity if we have to, but complexity equals cost. And if the complexity doesn't yield an increased effectiveness benefit, then it is merely a detraction to everyone and is a societal burden with no benefit. And at that point, a federal preemptive legislation is actually something that makes much more sense. I mean, the concept that HIPAA and GLB were floors and not ceilings never made any sense for those exact purposes. Now, there hasn't been the same explosion at the state level in terms of the variety of obligations. There are a number of them, but they are perhaps more banded in the variety of obligations. But still, these are the kinds of concepts that the more we can avoid complexity, the more we can enable regulators to be speaking to each other, lawmakers to be speaking to each other, lawmakers to speak to regulators so they can understand what can and can't be done on the back end of an equation. All of those things will actually promote the better implementation of technology and, more importantly, the more effective compliance related to the rules as well.
I also will just add, if you got federal preemptive data breach notification statute out there, which I don't think you're going to anytime soon, but imagine, my worry actually is that the definitions in it would be so narrow that they would leave out the entire Internet of Things sensor data problem, and that would actually be bad from my point of view. So I don't think that's going to happen one way or the other, but just something to, yeah, Julie will take care of that.
Other questions? Jordan?
Thanks. Until these state laws come about, do you have concern that some of this usage can lead to a two-tiered system in which privacy becomes a luxury item? For instance, the progressive snapshot insurance. There may already be various state laws to prevent the company, for instance, from demanding that you put this tracking device in your car. There may be a law that says they can't draw the inference that opting out of that system says anything about your driving abilities or your risk profile, but they can freely offer you a much cheaper insurance plan if you opt into that program. And you can imagine this happening across a number of different devices and a number of different industries. A cheaper electric bill if you put in the smart meter. A cheaper insurance plan if you wear the insurance company's proprietary Fitbit equivalent. And the only way out is if you can afford to pay more for the other plan. And so is that a risk, and is there a way in which we should address that problem?
So I wrote a paper called Unraveling Privacy that is about that. And it's a really hard problem, and I don't have a good answer in terms of how to fix it. But the reality of Snapshot or any other such discount program is it's really not a discount. I mean, what's happening, right? Well, two things are happening, by the way. Progressive is collecting a massive data set on driving in the United States. That is of incredible economic value, apart from its implications for insurance. Okay, but that's a footnote. In addition to that, the real issue becomes if you don't, at some tipping point, if you don't sign up to put the sensor in your car, then a stigma attaches to you that you must be a bad driver. Right? That's called, in economics, that's called the unraveling effect. I start to make inferences about you because you won't disclose information to me, and therefore you must be of the bad type, right? Now we're not there yet in insurance telematics devices, but it's not actually that hard to imagine that you get there in car insurance, for example, where all the good drivers are disclosing their insurance, their information to their insurance companies to get the discount. And everybody who doesn't do that is by definition a bad driver and paying more. When I tell that to people, or we talk about that, people seem to think that's okay in car insurance. It doesn't seem to bother people. But as soon as I say, okay, well then let's apply that to Fitbit. Let's apply that to whether you smoke. Let's apply, we can tell an unbelievable amount about you from these wearable fitness devices right now. Then suddenly people get all nervous and freak out and say, well, no, it shouldn't, I don't like that. So we're going to have to really figure out where do we want to constrain that kind of economic activity and where don't we? It's anybody's guess actually what will happen, but I do think it's a real problem.
Joe? And I think what he's articulated is effectively the gut test of privacy, which is whether you have the yucky feeling or not. Mm-hmm. And the reason is, in many ways, your driving habits are publicly observable. Most people don't have a major private compound unless you're Justin Bieber, in which you can drive poorly, and apparently he would prefer to close streets down to drive poorly in any case. But your personal habits are not meant to be publicly advertised necessarily. And your driving habits, which, today, okay, if you don't have your progressive bit, you have an easy pass. So if the state wanted to, they could determine whether you're speeding. Because if you go between toll booth A and toll booth B on the New Jersey Turnpike in X amount of time, then you're speeding, which is why it's always good to pick up gas and have a soda. The other thing, apart from that, your phone can locate you on the highway. You've got various other things. The first thing that started a lot of this was the tread wear tire indicator inside your tire, because that is actually mandated by the government to be in your car. And it doesn't necessarily broadcast. I mean, now it may, because it may touch into a part of the car that broadcasts. But that was only meant to help understand tread wear. But it understood the revolutions of the tire. And you can figure out the speed of the car. And by the tire wear, you can figure out your cornering habits. And so those kinds of things are in there. So I think people have less of a yuck factor in the car because it's generally observable behavior. Whereas the Fitbit is nowhere near as observable, and people consider that significantly more personal, which, when you go back to the search cases, is what was in plain sight, what wasn't, what was behind your home, and those became the U.S. expectations of privacy. Europe has a much lower tripwire in terms of data collection and where the expectation of privacy begins and ends. And India, the tripwire is different. I mean, this is not just within the legal construct, it's also within the cultural construct of nations. And so these are factors that are context-specific, that are also person-specific, because you have a range of opinion of what I think might be personal, someone else may not think is personal. So these are difficult issues, but you are absolutely right that it's going to break out into an economic equation, and if it causes unraveling or not is a question, but I mean, unfortunately, it mirrors what happens in a lot of the other parts of the real world, and IoT is no different than that.
And even in the car context, there's a Supreme Court case in terms of the reasonable expectation of privacy suggests that, yeah, you can theoretically track somebody, but when it's that easy, it becomes constitutionally problematic. So even in the car context where, you would have thought that is an easy one, but at some level, when it's perfect knowledge over a 24/7 basis, even that one became a hard case.
We'll take one last question, just an interesting little footnote. We've talked a lot about the automotive industry. Does anyone know, I actually looked into this because I ever talked to some Mercedes-Benz lawyers, what the first onboard computer was in a modern vehicle? Does anybody know the year, make, model? Anybody? It was the 1977 Oldsmobile Toronado, which had an onboard computer governing ignition for fuel efficiency purposes. It was right after the gas crisis of 1976. Some people in the room are old enough to remember pushing an Oldsmobile Toronado into the gas station because it was out of gas because of odd even rationing. But one last question, and then we'll wrap up.
Hi. I'm wondering if anyone on the panel wants to comment on sort of the corollary issue. The discussion's been mostly focused on the prospective sense of who can you make an agreement with about using your data, who do you know your data is going to. I'm wondering, I mean, particularly as a litigator, your sense of how all this data, and it's partially a big data question, but because of the Internet of Things, it becomes a third-party custodian issue of use in litigation. So let's say we know how Professor Felton slept last night, and he gets into a car accident this evening, so somebody subpoenas Fitbit to get that data from their servers. I mean, the game on social media has pretty much been played, and we know that anything you post to third-party social media sites is fair game in civil litigation. I'm wondering if your thoughts, if that's the way it's going to go for IoT data.
I presented about that to the 10th Circuit recently, and there were a whole bunch of litigators there in addition to the judiciary, and I really don't think they could get out of the room fast enough because they were all thinking about briefs that they wanted to go, update. I mean, absolutely. These commercial services right now, note, this is also a footnote, privacy policies sometimes mention that it can be subpoenaed and sometimes don't, although most of them are pretty good about that. But sure, if I were a civil litigator, would I be subpoenaing Internet of Things data all over the place? Absolutely. Will criminal investigations be subpoenaing? I mean, do you want to know, somebody says I was at home at 10 p.m. on a Tuesday night, that's my alibi. I could subpoena Nest thermostat, which has motion detectors in it and can tell whether I was home and knows whether it's me because it tracks, it can identify different individuals. I can subpoena your garage door opener. I can subpoena whether your oven turned on and off. I can subpoena. There's going to be an infinite number of ways to figure out whether you were home or not at that time, including where was your car. I mean, and on and on and on. So definitely going to be interesting. The other, besides litigation, civil and criminal, is just surveillance. How are we going to treat it when the NSA / other parts of the government start looking at, if they aren't already, which I think they are, given the CIA chief information officer's quote about Fitbit, how do we think about that? That's a whole additional problem. But the litigation uses are going to be big, and I have to say, for the companies making these products, I think it's going to be a bad thing, because when somebody starts subpoenaing Fitbit and consumers start to say, wait a minute, huh? I didn't know that was possible. That's gonna be a problem from a marketing point of view.
Just don't forget, what's good for the goose is good for the gander, and it will also be defense, not just prosecution and litigation. And there was a case which dates back to merry old England of a highwayman, and he understood he was going to commit a fairly large criminal act, and he set up a set of relays with fresh horses, and he rode like a madman from London to a neighboring town in a time that it was conceivably impossible to make that ride. And he was drinking in a tavern, and his alibi was it couldn't have been me because I was drinking in a tavern and no one could make the ride that fast. So you could see people setting up, I left my Fitbit at home on purpose. My car was parked so that I have created an alibi with my technology. And we also have to start figuring, no one is really talking about, I was on a conference call during the security panel, so you guys might have talked about that, but, as you start getting into software making decisions for you, you also get into people designing software to fool the software making decisions for you. So software agents are going to be developed with malfeasance in mind as well. And so all of these things, and we still haven't, I think, had a case, or you might know if we did, where an automated decision is thwarted by another automated decision, and you can't actually find a human involved in the automated decision. So these are all going to be issues we're going to be dealing with in one way or another, and it's going to be an entertaining future. And, the one thing from a privacy and security point of view is there is job security.
And lastly, sort of, I start off by saying who owns and controls the data is the fundamental question here. Your question puts a spotlight on the implications of who owns and controls the data, and everyone is sort of searching for the right analogy. Is this like telephone records? So it's a business record? Is it like the files in my home? Because it's my electricity and it's my car that I own, and the wrestling, I think, about what is the right metaphor and what is the right framework is just beginning.
All right, well, I've been personally assured by Joel that there's no RFID dust in the lunch. Exactly. So on that note, let's take a break. Thank our panelists for their wonderful remarks.
Oh, yeah.